Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back, everyone, to the Aitken Robertson Legally Speaking YouTube channel. And today we are delving into the complexities of sexual assault cases with the esteemed counsel, Phil Stiles, joining us today. Phil, can you outline for our viewers the typical process that's involved in handling a sexual assault case from start to finish?
I like to go by a step-by-step method. I almost have a template for how we do these. Step one involves the collection of evidence. Even before anybody retains, or even if I've just had an initial conversation with somebody, the first step is always to try to seize whatever they can get their hands on that might help them in their case. Why that's important is surveillance video, for example, or CCTV footage, or any security footage usually elapses in about 30 days or less. So it's important if someone thinks that something might be caught on camera, or if someone knows that there's a particular vicinity where the allegation was alleged to have happened that could have caught either private security footage or some type of public police camera, then it's important to try to get a hold of that evidence right away. It's not limited to video footage. Everybody's memory of something is most clear, obviously, closer to when the incident happened. So anybody with anything relevant to add to the case, it's a good idea to simply ask them to preserve their memory by way of a written statement without mentioning anything to them about anything that might contaminate their evidence. Just get them to record for themselves what they recall. And so after the collection of evidence, what we usually do is we review what the police have. So I order the disclosure, and usually I order more disclosure, and we get the actual statement from the complainant usually, or complainants, and we review precisely what's being alleged, the where and when. And then from there, that prompts someone accused to do their own thinking about what the allegation is and identify inconsistencies between what actually happened according to them and what's alleged. And so after the accused makes a fulsome written statement of their own to preserve their own memory, then we get into speaking to the Crown. Usually you have to temper expectations for an initial chat with the Crown, because the Crown often doesn't budge when it comes to a sexual assault file. They usually want to see it through to trial. Knowing that, you want to be very careful about what you're telling the Crown, because you want to make sure you're not divulging any important facts in your case. And you essentially, unless it's with clear instruction, want to keep your cards close to your chest. From there, a judicial pretrial conference is usually required. And the idea is we determine how many witnesses are going to be testifying, what the trial is going to look like, whether there's any special applications that we need to make. For example, whether there's an issue about whether there's relevant prior sexual history evidence or other sexual history evidence that we might want to include in our case, which would need a special application. So in any event, we decide at the judicial pretrial conference with the judge what the case is going to look like when it gets to trial. And then we set the trial, and the very last step is to run the trial. What's important is throughout the whole journey, in someone's mind, they treat an early resolution as a bonus, but that they protect themselves as if they're going to trial from day one. And so ultimately, it's the trial that is the most important defense for somebody who has been wrongly accused of something. And that's the steps from start to finish.
And then during when would a client typically be required to appear in court?
Usually we file what's called a designation of counsel, which gives the lawyer permission to appear on somebody's behalf in court. There are certain times when the accused presence is definitely required. Some examples are certain pretrial applications, like the one I just mentioned, a 276 application, and also required during the actual trial. You must be present for your own trial.
How long does it usually take for a sexual assault case to be resolved from the start to finish?
In my experience, unless there's a glaring issue that would cause a Crown to think that there was a very dim prospect of conviction, usually they take at least a year from start to finish or more. I would say start to finish, i.e., the day someone is charged until the matter is completely finished, it's usually between 12 and 14 months. And that's not a firm average. That's just my guesstimate.
Thank you so much, Phil, for all the information. And thank you, everyone else, for joining us today on the Legally Speaking Aitken Robertson YouTube channel. So don't forget to like, subscribe. And until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.